here's what I want you to focus on. The interesting thing is, notice the words. It refers to a person and a party being impeached. Now again, we know that the framers gave a lot of thought to the words that they chose. They even had a style committee during the Constitutional Convention. They could have written civil officers here. I mean, they did that elsewhere in the Constitution. That would have ultimately limited impeachment trials to current officials. But instead, they used broader language to describe who could be tried by the United States Senate. So who could be put on trial for impeachment other than civil officers? Who else could a person or a party be? Well, really, there's only one possible answer: former officers. And again, that actually might explain why, during the Belknap trial, Senator Thomas Bayard of Delaware, he later became the Secretary of State of the United States. He sat right where Senator Carper is sitting now. He found this point so compelling that he felt compelled to speak out on it. And during the trial, he concluded that the Constitution must allow the impeachment and trial of people and parties who are not civil officers. And the only group that could possibly encompass was former officials like Belknap, and of course, here, like President Trump. And just so we're clear, in full disclosure, this is another argument that was not addressed by President Trump in his rebuttal. And we know why they didn't. Because their argument doesn't square with the plain text of the Constitution. There is one provision that President Trump relies on almost exclusively. Article 2, Section 4. I'm sure you'll see it when they present their arguments. Their argument is that the language you'll see on the screen somehow prevents you from holding this trial by making removal from office an absolute requirement. But again, where does the language say that? Where does it say anything in that provision about your jurisdiction? In fact, this provision isn't even in the part of the Constitution that addresses your authority. It's in Article 2, not Article 1. And it certainly says nothing about former officials. President Trump's interpretation doesn't square with history, originalism, textualism. In fact, even Chuck Cooper, the famous conservative lawyer I mentioned earlier, with clients like the House Minority Leader, he has concluded that this provision of the Constitution that President Trump relies on cuts against his position, his words. And that's because, as Cooper says, Article 2, Section 4 means just what it says. The first half describes what an official must do to be impeached, namely commit high crimes and misdemeanors. And the second half describes what happens when civil officers of the United States, including the sitting president, are convicted. Removal from office. That's it. In Cooper's words, it simply establishes what is known in criminal law as a mandatory minimum punishment. It says nothing about former officials, nothing at all. Given all of that, it is not surprising that in President Trump's legal trial brief, 75-page brief, they struggled to find any professors to support their position. They did cite one professor, though. Professor Kalt, who's an expert in this field, who they claimed agreed with them that the only purpose of impeachment is removal. Professor Kalt's position, which they had to have known because it's in the article that they cite in the brief, is that removal is, quote, not the sole end of impeachment. Actually, in that same article, he describes the view advocated by President Trump's lawyers as having deep flaws. And again, you do not have to take my word for it. You can take Professor Kaut's word for it, the professor they cited in their brief filed yesterday, because he tweeted about it. And on the screen here, this is what he had to say. I'm not going to read through it in great detail. I'll just simply give you the highlights. President Trump's brief cites my 2001 article on late impeachment a lot, but in several places, they misrepresent what I wrote quite badly. There are multiple examples of such flat-out misrepresentations. They didn't have to be disingenuous and misleading like this. This key constitutional scholar, relied on by President Trump, said it just right. I have explained in great detail the many reasons why the argument that President Trump advocates for here today is wrong. I just want to close with a note about why it's dangerous. Lead Manager Raskin explained that impeachment exists to protect the American people from officials who abuse their power, who betray them. It exists for a case just like this one. Honestly, it is hard to imagine a clearer example of how a president could abuse his office, inciting violence against a co-equal branch of government while seeking to remain in power after losing an election. Sitting back and watching it unfold. We all know the consequences. Like every one of you, I was in the Capitol on January 6th. I was on the floor with Lead Manager Raskin. Like every one of you, I was evacuated as this violent mob stormed the Capitol's gates. What you experienced that day, what we experienced that day, what our country experienced that day is the framers' worst nightmare come to life. Presidents can't inflame insurrection in their final weeks and then walk away like nothing happened. And yet that is the rule that President Trump asks you to adopt. I urge you, we urge you, to decline his request, to vindicate the Constitution, to let us try this case.